In this video, I'll be talking about two essential elements of forming a contract, and that is acceptance and consideration. So in a previous video, I've already talked about the first essential element, and that being the offer. Now, the second essential element is acceptance. There are rules of acceptance. So for the party that is accepting the offer that's made, there are rules that we have to stick to in order for the contract to be valid. The first rule over here is that acceptance must conform to the offer. So if I'm the offeror, I made an offer to you, and I'd specified that you have to accept that offer as an offeree. You have to accept it via email. If you were to accept it through a phone call, say for instance, that wouldn't be valid because you did not conform to the offer. In addition, what that point means is that you have to accept it as an offer. You have to accept the offer in reliance of what I promised to do. So the offer that I made to you. So you can't accept an offer that. So you can't accept. So if I were to offer you something, you can't then claim that you're accepting it based on or relying on an offer that you'd received from someone else. That wouldn't be a valid acceptance of the offer, and hence you wouldn't have a valid contract. The second point over here is that the acceptance has to be verbal or in writing, or it can be inferred from the conduct of the party. So don't think that because there's a contract and you want to establish a contract that it has to be an acceptance through signing the papers. That's not the case. The court can infer an acceptance through your own conduct. So let's say, for example, that we had a contract that you were gonna build the house for me, and second day we agreed on the terms, and we discussed that, negotiated the price. So the second day you went and you started work, that your conduct would infer that you'd accepted my terms and conditions and you agreed to be part of this contract. This fourth point over here is that the offer can be accepted without signing. Basically, is what we talked about in terms of inferring that acceptance from your conduct. You can also accept an offer verbally, so you don't have to sign. If it's not specified by the offeror that you have to accept the offer through signing a contract or through writing back to say that you've accepted, you can accept it through verbal communication. And then the final point is that the offer can only be accepted by the person to whom the offer was made. So if I made an offer to you, your brother or your sister can't accept the offer on your behalf. That wouldn't be uh, acceptable. Okay, so a common question that's asked is, when is a contract established? So as soon as you make an offer. Is it as soon as you make an offer? It's not the case. No, the acceptance is established as soon as the offer, the acceptance of the offer is communicated back to the offeror. So as soon as the offeree accepts the offer and that's communicated back to the offeror, that's when the contract is established. Now, silence is not a form of acceptance. So I can't make you an offer and say, buy my house for $950,000, and if I don't hear back from you for the next 3 days, I just assume that you accepted. That wouldn't be allowed. The courts wouldn't permit that as an acceptance of the offer made. Another point that also takes place a lot, especially when you're negotiating terms and conditions, is that you might receive a counter offer. And a counter offer by law is not an offer. A counter offer is not an acceptance of an offer, but it is considered as a new offer. And I'll give you an example. So let's say, for instance, that you were negotiating with me the terms and conditions for starting a construction project. And I said, I'll hire you as a contractor, as the builder, if you were to do the job for, let's say, $3 million. And you said, well, I will accept this offer, but you have to pay me $4 million. You can't then, you as the person that just raised that price, you can't claim that this was acceptance. This was a counter offer that you made, so it's a new offer, and now you became the the offeror, I'm the offeree. I have the ability of either accepting that offer or rejecting it. This is the case over here that's mentioned. That's the authority case, basically, that explains the fact that a counter offer is not acceptance, but is a new offer. The third aspect, or the third element of forming a valid contract, is consideration. What is consideration? Consideration, you can think of consideration as basically the price that you pay for the promise. So let's say, for example, that we had an agreement that I was to supply you goods. Your consideration would be the price that you would pay for me to supply these goods. So it's basically the price paid in return for the promise. Again, consideration has a couple of legal aspects that we have to abide by. The first legal aspect that's mentioned is that consideration has to be legal. And what that means is that if I were to ask you to you know, to, for instance, build a house for me, and in return, I'd, as consideration, I'd kill someone for you. That wouldn't be accepted as a legal consideration, because the act of killing is not legal, so it wouldn't be considered as appropriate consideration. The second point is that consideration has to move from the promisee. So you made the promise to me, you're a promisor, I am the promisee. I have to pay for your promise. So I'm the promisee. That's why consideration has to move from me to you, from the promisee to the promisor. Um, Third point is that consideration has to be real, but it need not be adequate. And an example over here is that, let's say that there's a house in Botany, and it's worth $2 million, and I decide to sell it to you, and we agree on selling that house for $1. So you'd take that house and you'd pay me $1. Would that be allowed? Legally, it would be allowed, because you'd paid consideration, the $1. This is real money, but it's not necessarily equal to the market value. And that's what this point is saying. It must be real, but it need not be adequate. This fourth point over here, consideration must not be in the past. Um, what it basically what it means is that if you'd had paid for something in the past, you can't, and we have a new agreement now between us, you can't use whatever you paid in the past and say, because I'd already paid for you in the past, you should just accept it right now and for this new contract. That wouldn't be allowed. And the final point is that any performance of an existing duty is not consideration. So if you, for example, if I agreed to supply you materials for your swimming pool, and we signed a contract, and we agreed on a price, and you were to pay me, let's say, for example, $100,000, and then you asked me to supply you materials for your house, and you gave me a payment, and I said that I'm going to do that tomorrow. I can't come tomorrow, so I can't come to you tomorrow and say, okay, given that we've already agreed on that swimming pool in the previous contract, that's going to be my consideration. So me supplying you materials for the swimming pool would be consideration for your house. That wouldn't be accepted, because I already have an existing duty with you in that previous contract for the swimming pool, and I can't be using that as consideration for the new contract that we decided to initiate.